This House will come back to order. House will come back to order. Mr. Clerk, you want to ring the bell? Okay, I thought it might be good to go ahead and do our birthdays today. We have a birthday today, and I want you to notice the campaign slogan: experience. Don't say anything about good looks. Don't say anything about intelligence. Experience. How many years' experience did you have? Huh? Yeah. So let's all join in and wish a happy birthday to our dear friend and Chairman Don Hogan. Of course, some of them here are still trying to figure out what experience that matters. What is it that matters? Oh, well. Happy birthday, Mr. Chairman. All right, we're going back now to the rules calendar. Going to the rules calendar. All right, we're going back to the rules calendar. The clerk will read the caption to House Bill 1354.
House Bill 1354 by Representative Holcomb of the 81st and others, to be entitled an act to amend Article 4, Chapter 5 of Title 28 of the Official Code of Georgia Annotated relating to the Claims Advisory Board so as to create the Wrongful Conviction Compensation Review Panel. This bill having referred to the Committee on Judiciary Non-Civil. That committee recommends this bill do pass by committee substitute.
Chair recognizes Representative Holcomb to present the bill.
Thank you, Mr. Speaker.
Just a minute, Mr. Representative. All right, let's give the gentleman some attention. The gentleman may proceed.
Thank you, Mr. Speaker. It's my pleasure to present to you House Bill 1354. This builds upon the work that we've done to compensate the wrongly convicted. The title of the act is the Wrongful Conviction Compensation Act. The idea behind the bill is to set into law clear procedures and policies that will guide this process going forward. So instead of it being done on an ad hoc basis coming through the General Assembly, what this proposal would do, and the meat of the bill is on Section 4, which is on page 3 of the bill, would be to set up a wrongful conviction compensation review panel. The statute has, or the proposed statute has, clear standards in terms of what would need to be demonstrated, and that is on the bottom of page 4 and beginning at lines 85. And the bottom line is this: an individual would have to prove that they're innocent. They would have to demonstrate with evidence, with testimony, that they were innocent. And then if they were innocent, then a recommendation could be made in terms of compensation. The board would consist of expertise, and it would have a judge who would be appointed by the Chief Justice of the Supreme Court of Georgia, a district attorney, a criminal defense attorney, and then an attorney, forensic science expert, or law professor with expertise in wrongful convictions appointed by the Speaker of the House of Representatives, and then similarly, an individual with similar experience appointed by the President of the Senate. So these individuals would have the expertise to evaluate these claims, to listen to the evidence, and then to make a recommendation. As it works now, it goes through the Claims Advisory Board, and that does not have the requisite experience and systems to really handle this process. My hope is that it would be very rare that this would ever be needed, but if and when it is needed, we'll have a good plan in place for evaluating these measures. The compensation, the legislation provides a floor and a ceiling. The floor would be $50,000, the ceiling would be $100,000, and that's found on page 7 of the bill. The average across the country is around $70,000, and 38 states have similar policies to what is being proposed here. So the majority of states have a statewide compensation process. The federal rate is also approximately $70,000, and after this panel hears the evidence, it would make a recommendation to the Claim Advisory Board, so that would still be in existence, and then it would go up to the Chief Justice to review and accept the findings. And if the Chief Justice reviewed and accepted, it would then be subject to appropriations just as the current process is. But it would take it out of the hands of the legislature, create a new process with clear guardrails. And then in terms of support for this, we worked really hard on it. I want to thank Chairman Efstration for his hard work on it, and also Chairman Houston for her support of this measure, and Representative Hughley for working on these measures for many, many years. The prosecutors are supportive of this. The defense counsel, lawyers are supportive of this. The Georgia Innocence Project, who has done a lot of work to help those who have been wrongly convicted, is supportive of this. So I think it's a very important measure, one that I came around to pretty slowly, as I acknowledged in my remarks earlier. I am a former prosecutor. I don't want anybody to be compensated that doesn't deserve it, but this sets forth the policy to make sure that it would be only for those that truly deserve it. So with that, I'd be happy to answer any questions if there are any.
You do have a few questions.
Okay. I'll yield,
You
Mr.
yield.
Speaker. I will. Thank you.
Chair recognizes Chairman Parsons to your left for a question.
Thank you, Speaker. Does the gentleman yield?
I do.
Yes, sir. Isn't it true this idea has been around for some time? I know for at least the last 15, 16 years there's been people have had, legislators have had bills in for this type of thing. Do you know?
I think that's true.
Okay. Well, isn't it true, though, based on what you said, it would be taking this out of the hands of the legislature, but proving guilt or innocence would be actually taken away from the court in which the original conviction was held. Isn't that true? You said that this commission would actually would determine whether that person was guilty or innocent and whether or not they should have compensation. Is that not true?
No, and I'm sorry if I wasn't clear on that. An individual would have to already be exonerated to get to this stage. So they'd have to go through that court process, which is really challenging and difficult. And so there's built in, I think, the safeguards to protect that. So this would deal with the types of situations that we had tonight, where individuals were clearly not guilty and they were exonerated by the legal system itself.
Thank you.
You're welcome.
Do you further yield?
I do.
Chair recognizes Representative Derek Jackson up in the gallery for a question.
Does the gentleman yield?
Yes.
Although I appreciate the spirit and the intent of House Bill 1354, with regards to the 50 to 100,000, which seems to be a very large gap, could you share with us, because not all crimes are created equal, how do we minimize, or this commission minimize, the subjectivity that may very well cause for one to get 50,000 versus 100,000?
That's a great question. And one of the criteria within the statute is for them to have consistency. So we want there to be more consistency across the board, and they would provide statements as to the basis for their judgments. And this would only apply for people who spent time in prison, but one factor that could impact the range could be the skill level of the individual who is incarcerated, their earning power, things like that. So it gives a little bit of flexibility for the panel to consider, and those would be part of the factors and evidence that would be presented at the hearing.
Do you yield for one more question?
Yes.
So what is the makeup for the commission? Can you expound upon who exactly would be part of this commission?
Yes, I explained it, and I'll reference it again. It's on page 4, lines 72 to 77, and I went over that before.
Okay, thank you.
You're welcome.
Do you further yield?
Yes.
Chair recognizes Chairman Houston to your right for a question.
Is it not true that I've served on this several times, and is it not true, I appreciate you doing this because it's a very emotional thing, and is it not true the people you have selected to decide this won't be quite as emotional as some women that you might have on the thing? Not that women are emotional, but anyway. But I do appreciate you doing this.
Thank you.
Thank you. And if this passes, if I've ever asked to do it again, I'll never have to. Thank you.
Thank you.
You finished?
Yes, Mr. Speaker, I'll yield the well, and I ask for your favorable consideration. Thank you.
Gentleman has yielded the well. We have other members that wish to be heard. Chair recognizes the chair of the Judiciary Committee, Chairman F. Strachan, to speak to the bill.
Thank you, Mr. Speaker. I wasn't planning to speak on this legislation tonight, but with some of the questions that were asked, I just wanted to give a brief recollection of some of the history here. I know we got a lot of bills on the calendar, so I'll get right to it. But, you know, my first experience here at the state capitol was as an intern. I got to sit in on meetings, see what was going on, and this was almost 20 years ago. This issue was being debated in a committee. It was how to address compensation of wrongfully convicted individuals. And when I was elected, I was certainly familiar with this issue. I am a member of the Appropriations Committee. I'd see the resolutions that would come through each year. I was familiar with the lack of consistency in the process with respect to how legislators might analyze resolutions that are coming through in that procedure. I was familiar with Representative Hughley's work and the study committees and work that have been done over the years on this issue. And over the off season, I was approached by folks from the George Innocence Project who said, you know, we really would like to work on some consistency. And so what does this legislation do here today? It, number one, provides a consistent process that allows experts in the areas of criminal justice, issues around wrongfully convicted individuals to analyze these issues. And secondly, it provides a procedure that we can ultimately use our legislative discretion to determine whether the appropriation is appropriate, but that's with a recommendation from experts, and it's with consistency in the law as to what appropriate compensation should be, a range of what that amount should be, so that it isn't different based upon different claims, so that legislators aren't sitting there attempting to judge whether or not the case was appropriately ultimately determined the person who was wrongfully convicted truly was not guilty. Look, the bottom line is a person who is wrongfully convicted of a crime can never be fully compensated monetarily for that time. But by having a panel that reviews these cases, makes a determination as to whether it is appropriate to compensate that person, and then provides a recommendation for what that compensation should be, that is then sent to, ultimately, the House Appropriations Committee to review that and decide whether or not the appropriation should be made. That is a process that we need to implement in the state. And in my view, you can support these resolutions or oppose these resolutions and recognize the need to have a standard process that we follow in these circumstances. And just the final thing I want to cover, Representative Holcomb went through, I think, a lot of the specifics of the bill that are helpful to know. But we can finally, once and for all, have a process in place where experts, judges, prosecutors, criminal defense attorneys, forensic science experts can review these matters. And to answer Chairman Parsons' question, this is only after the conviction has been determined to have been wrongful. It is only after, in a court of law, it has been determined that that person was innocent. Only after in court that happened could a claimant then pursue a claim under this statute. And so that judicial process is preserved. We're just letting experts on this compensation board, it's a sub-panel of that compensation board, make that determination, send those recommendations to the House Appropriations Committee so we can then make a decision. Legislative authority is not eroded here. In fact, it's strengthened because we get recommendations from experts who know what they're talking about, and we get guidelines of what that compensation should be. For those reasons, I'd encourage you, regardless of how you feel about compensation in these circumstances, it's good policy to have a procedure in place and have consistency and the amounts that are recommended for these circumstances. I yield the will.
Chair recognizes Representative Fleming to speak to the bill. He waives. Chair recognizes Representative Hughley to speak to the bill.
Thank you, Mr. Speaker, ladies and gentlemen of the House. I rise in full support of this measure. As you know, I probably have more compensation resolutions than anybody in this chamber. And it is a traumatic experience for the legislator, for the subcommittee that's appointed, for everybody involved. And some of those resolutions have, in essence, put the person on trial again. And we've had people that have been incarcerated for 10 years, 20 years, 30 years. And you can never give a person back the time they've lost from their family, the time that they were unable to go to mother's funeral or father's funeral or see their children grow up. We have a good justice system here in the state of Georgia, but when we are wrong, when the state of Georgia is wrong, we have an obligation to try and make it right. And this bill gives us an outline so that each person who is similarly situated will be treated the same. If you went back and looked at the compensation resolutions that have been passed by this General Assembly, you will see the inequities. Some people get various amounts. We've even had one resolution where the person was required to be drug tested every year in order to make sure that his annuity would continue. This would eliminate that, because right now the people who are the Claims Advisory Board are agency heads. They are not people who are steeped in law. And what we're going to do is have legal experts review this, give us a recommendation. It will come to us through the budget process. So we're not ceding our authority, we're improving it by getting expert opinions as it comes to us. And then it won't matter if the person is from Columbus or Hiwassee, or if the legislator that represents that area is a R or a D. What we want to do is make sure that justice is served. And I submit to you that this will help us in terms of being fair to all of our citizens. So I ask you to support this bill. Thank you, Mr. Speaker, and I yield the will.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 1354, the ayes are 157, the nays are 11. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1424.
House Bill 1424 by Representative Paulo the 32nd and others to be titled an act to amend Chapter 27 of Title 50 of the Official Code of Georgia Annotated relating the Georgia Lottery for Education Act, so as to provide that administrative procedures and actions regarding bona fide coin-operated amusement machines shall be subject to Chapter 13 of Title 50. This bill having referred to the Committee on Regulated Industries, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Powell to present the bill.
Thank you, Mr. Speaker, and ladies and gentlemen of the House. The bill that I'm going to describe tonight is nothing new to this body. We passed this bill last year twice. This deals with the COAM industry and the COAM games that fall under the jurisdiction of the Lottery Commission. This bill has been pared down to do only 4 things for the benefit of the COAM industry and for the benefit of the people of Georgia. First, what it does, it exempts veteran and fraternal organizations from the 50-50 rule. That means that they don't have to be selling merchandise to have COAM machines in their organizations, your VFWs, your AMVETs, and places like that, the fraternal organizations. It changes the dollar amount on the Class A games. These would be the things that you see, the crane games and those kitty-type games that they put prizes in. This raises it from $5 to $50, the amount that they can put into these gifts. It brings the industry under the Administrative Procedures Act. So it gives them safeguards as well as it does for the Lottery Commission. It regulates them. And then finally and last, but what it does, it establishes a gift card, non-cash redemption. Y'all may remember this discussion from last year. The idea that a lot of us has had, where you see in a lot of cases that there are those people that get caught paying out cash, that by going to the gift card so that they can redeem for non-cash or prizes or restaurant or certificates, then this would hopefully, and what it'll do, it will stop any illegal trade. That, Mr. Speaker, is what this bill does, is pared down. If you want to know why we've done it so many times, it's because it gets over to the Senate, and some of them folks over there like to get cute with it, so we're going to send it over to them one more time. That, Mr. Speaker, is what it does. Since most everybody knows what it does, and I'm going to answer any questions, but I'm going to be very brief.
Do you yield for questions?
I will.
Chair recognizes the Minority Caucus Whip, Representative Wilkerson, to your left for a question.
Thank you, Mr. Speaker. Is it not true that the addition of the gift cards would allow people to use it versus just buying, food in the store at high prices? They can actually have another option of using those funds.
It will. They'll be able to use that gift card like a credit card, except it'll be a non-cash redemption credit card. They can go outside to the Walmarts or wherever, or they could go to a Home Depot, or they could go to a Longhorn or anywhere else, like a Visa card, except it would be blank, so it would be non-cash.
No further questions.
Ladies and gentlemen, I would appreciate your favorable consideration.
Chair recognizes Representative Stacey Evans to speak to the bill.
Thank you, Mr. Speaker. Good evening, ladies and gentlemen. I rise reluctantly, believe it or not, Representative Powell, reluctantly in opposition to House Bill 1424. And the reason is I think that the aim of this bill is good. I think it does seek to address some of the problems with the industry. I don't think it cleans everything up, but I think it makes, give it the old good college try, and I think that's a good thing, and I want to encourage that. But ultimately, this is something that the industry has asked for. And we should not check our common sense at the door, ladies and gentlemen. If the industry wants it, it means the industry benefits. It means there will be more money to be made. And if the industry is going to ask us for something that benefits them, then I think the state should benefit further as well. We should not fool ourselves that these machines attract nuisances. They create nuisances and problems in our community. And just like with any gambling operation of any sort, we might be willing to take the bad if there is an overwhelming good. And I can't explain to you how the COAM industry was able to establish themselves in this state and only give us 10% of the proceeds for educational purposes, for Hope and Pre-K, which is what they do right now. 10% of what I've heard is either, depending on who you talk to, it's a $1.5 billion industry, it's a $3 billion industry. This is serious money, y'all, and our kids need it. We know there's a waiting list for Pre-K. We know that there are kids that need more money through the Hope Scholarship to be able to afford college. If we as this body later in the session, hopefully, decide that we should allow folks to vote on whether we will have casinos or horse racing, we are going to insist on 20% of those proceeds to come back to help education in some form or fashion. Why would we let the machines get by with less? I can't explain that. And so because of that, I'll be voting no on this legislation because I think the state deserves more from what these machines are doing to our state. Mr. Speaker, I would be happy to yield for questions if there are any for me.
Do you take a few questions?
Yes.
Chair recognizes Chairman F. Stration to your left for a question.
Is the lady yield?
Yes.
Representative, isn't it true that the folks who are playing by the rules currently will benefit from the passage of this bill?
I think that is true. There are folks that are paying cash illegally, and we know that. And so that's why I say when I started, the aim of this, to create this gift card, is meant to try to level the playing field between those that are paying cash and those that are not. But I think we got to remember, Mr. Chairman, that because people do think this is going to level the playing field because that gift card is like cash, we should all be very clear about what we're doing in here, ladies and gentlemen. We are allowing cash. It's just on a card. So some might say we're actually legalizing gambling without legalizing gambling. And if we're going to do that, we need to get something for it.
Isn't it true that for a system that's currently in place, this is an important protection for those who are playing by the rules? And only the folks who are not following the law are the ones who would truly feel the impact by this. In other words, if your complaint is more broad, maybe that should be in different legislation. But this bill is actually an improvement. Isn't that true?
It is an improvement, but it's an improvement that's going to allow the industry to make more money. If the industry is going to make more money than this state, our kids deserve more money. Why? We don't have to let this industry operate, ladies and gentlemen. And if we're going to let them here, we need to benefit more from this. We let no other industry of this kind pay this little. The lottery is required to return 35%, and they barely do 25%, and we get mad about that. 10%, y'all. I hope that we could do this cleanup, but there's no reason not to include an increased percentage. Mr. Speaker, if there are further questions, I'm happy to yield.
Chair, you do yield?
Yes.
Chair recognizes Chairman Houston to your right for a question.
Isn't it not true that by giving gift cards, we will collect some sales tax?
I believe that is true, yes.
But isn't it not true? I'm not opposed to this industry, but I would like for the lottery to get a bigger cut than 10%.
Absolutely.
That's all I'm asking for, is for the lottery to get more money.
I think we're on the same page there. Smart ladies think
Thank
alike.
you.
Thank you, Mr. Speaker. I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Representative Bennett rise?
Thank you, Mr. Speaker. Pursuant to House Rule 133, I ask to be excused from this vote.
Lady has that right, and the journal will so reflect. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 1424, the ayes are 88, the nays are 79, and this bill has, having not received the requisite constitutional majority, is therefore failed. What purpose does Chairman Powell rise?
Mr. Speaker, I'd like to ask for reconsideration.
Gentleman has that right. And because it's crossover day, that will be now. The gentleman has moved for reconsideration of this House's vote to fail to give House Bill 1424 the requisite constitutional majority. All those in favor of reconsideration will vote aye. Those opposed to reconsideration will vote no, and the clerk will unlock the machine. What purpose does Representative Saines rise?
Parliamentary inquiry.
State your inquiry.
Is it not true by allowing reconsideration on this bill that we give increased ability for individuals who get COAN gift card to utilize it for additional purposes that are more productive to their life?
If the gentleman so states, I'm sure he believes that to be true. The one thing you will do is get another chance to vote it tonight. What purpose does Chairman Gunter rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that when I was serving as a district attorney that the biggest pain in my rear was these convenience stores that were running these operations, and they were all done using cash?
If the gentleman so states, I'm sure he knows whereof he speaks. What purpose does Representative Stacey Evans rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that another problem with these gift cards is that unlike the way it is now, you are not allowed to use your winnings from COAMs to purchase alcohol or tobacco, and when we allow people to take that gift card out of the store, we can no longer put that safeguard, which this House has put in place for the safety of our state for many, many years.
The lady so states. All right, final one. What purpose does Representative Ridley rise?
Parliamentary inquiry.
State your inquiry.
Is it true that this representative don't have anything against using alcohol and tobacco, using those gift cards for that?
Nothing like a little perspective. All right. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the ayes are 117, the nays are 52. This House has reconsidered its action in failing to give House Bill 1424 the requisite constitutional majority. All right, that'll go back on the general calendar, subject to being voted during the evening. Clerk will read the caption to House Bill 1553.
House Bill 1553 by Representative Crowe of the 110th and others to be entitled an act to amend Chapter 2 of Title 42 of the Official Code of Georgia Annotated relating to Board and Department of Corrections so as to provide for adoption of rules and regulations by the Board of the Department of Corrections. This bill having been referred to the Committee on Public Safety and Homeland Security. That committee recommends that this bill do pass.
Chair recognizes Representative Crowe to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, this is House Bill 1553, also known as Bishop's Law. In 1999, January of 1999, Captain Robbie Bishop with the Villa Rica Police Department was shot and killed on a traffic stop on I-20. His murderer was later found, located in Canada, arrested and extradited back to Georgia, where he accepted a plea to life in prison without the possibility of parole. A few months ago, it was discovered that he had been moved from a maximum security facility to a medium security facility, had obtained access to a contraband cell phone, set up several social media accounts, and was posting on social media taunting the family of Captain Bishop on those social media posts. What this bill would seek to do is require that any time an offender is convicted of murdering a police officer in the line of duty, they serve their entire sentence in a maximum or close security facility. There is a mechanism for them to be moved if they needed to be moved for treatment or medical infirmary care. They can be moved, but it can only be done so with the written documentation of the department, and the family would have to be notified beforehand. So with that, Mr. Speaker, I will yield for any questions.
Do you yield for a question?
Yes, sir, I do.
Chair recognizes Representative Gravely to your right for a question.
Does the gentleman yield?
Yes, sir.
Is it not true that Officer Robbie Bishop's Memorial Highway runs through the city of Villa Rica, which Representative Chairman Jay Collins and I both share together?
Yes, sir. It sure
Gentleman,
does.
further yield.
I do.
Is it not true that it is widely believed by law enforcement and citizens in our community and across this state that Robbie Bishop was one of the best officers who could identify drug traffickers along Highway I-20 and was able to pull them off the highway, keeping our community safe, and that his life had a hit put on it by those trafficking drugs in other countries and here in our state?
I absolutely do know that to be true, yes, sir.
I appreciate this bill. Thank you so much.
Thank you.
Do you yield for questions?
Yes, sir. I'll yield for one more.
Chair recognizes Chairman Collins to your right for a question.
Does my friend yield?
Yes, sir, I do.
Is it not true that my first act as mayor of Villa Rica was to dedicate the Hope Bishop Justice Center as a testament to Robbie Bishop's service to not only our state but to our city, Villa Rica, Georgia?
Yes, sir, I do believe that to be true.
Is it not further true that the death of Captain Robbie Bishop still resonates with the residents in the West Georgia area, and he left behind numerous friends and family in that community, and they were very distraught when they saw this situation happen on social media? Is that not true?
Yes, sir, it very much is.
I wish to thank you for bringing this piece of legislation.
And thank you for your support, Chairman. Mr. Speaker, I'll yield the will, and I ask for your favorable consideration.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Chairman Houston rise?
I didn't mean to.
Okay. She waves. I'm assuming that Representative Gravely must be, his ghost pressed his button, I guess. Thank you, Representative Leverett. It's still on. Okay, there we go. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1553. The ayes are 171, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1516.
House Bill 1516 by Representative Gaines of the 117th and others to be entitled an act to amend Part 10 of Article 7 of Chapter 3 of Title 12 of the Official Code of Georgia annotated relating to the Georgia Music Hall of Fame Authority so as to provide for definitions. This bill having referred to the Committee on Creative Arts and Entertainment, that committee recommends that this bill do pass.
Chair recognizes Chairman Gaines to present the bill.
Is it on? There it is. How about it? Thank you, Mr. Speaker. Happy to present House Bill 1516. This measure allows the Georgia Music Hall of Fame the material that's currently sitting in the basement of the Special Collections Library at the University of Georgia in Athens to be displayed publicly in Athens. It was previously in Macon, but that facility is no longer open. It was sold to Mercer about a decade ago, and so this ensures that the material is available for display in Athens, which is another great hometown of a lot of good musicians. So, Mr. Speaker, I'd be happy to answer any questions if there are any.
You do not appear to have any questions.
Thank you, Mr. Speaker. I yield the will.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 1516, the ayes are 169, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1184.
House Bill 1184 by Representative Williams, 168th and others, to be entitled an act to amend Part 12 of Article 6 of Chapter 2 of Title 20 of the Official Code of Georgia Annotated relating the effectiveness of educational programs so as to require the administration of a nationally recognized college entrance exam to public school students in grade 11. This bill having referred to the Committee on Education, that committee recommends that this bill do pass by committee substitute.
Chair recognizes the distinguished member from Liberty County, Representative Williams, to present the bill.
Thank you very kindly. Thank you very kindly. Thank you, Mr. Speaker. You all can sit back down. I sat and started to nod some because it's getting a little late and I got a little nervous. Chairman of Rules said he only wanted to hear bills that were earth-shattering and time-stopping. I gave him a bill, and the earth quit shattering and the clock kept running. This is House Bill 1184 by committee substitute LC 490943S. Very simple bill. Probably the most important bill you will vote on tonight. I voted on the pigs and other things. This bill affects Georgia profoundly. Very simply, SAT and ACT tests. This allows local schools to give the test during school hours, helping some people that have to drive many miles to take the test. We might catch somebody that may be one of the world's great inventors in the future. This bill does not mandate any school system to opt in. It is you may. It is good for people in Liberty County drive from Hinesville to Savannah to take this test. On Saturday mornings for 4 hours, a lot of people have to work, and it's tough. Let's make sure we add another arrow to the quiver that will make it simple and easy to produce this state's next great minds. Mr. Speaker, if there are any questions, I'll stand for them. If not, I will reluctantly yield the well.
Well, you get to stay there a minute if you want to take a question.
I'll take a question.
Chair recognizes Chairman Dubnik to your left for a question.
Thank you, Mr. Speaker. I hate to ask the gentleman to yield when I stand between you and reluctance, but would you yield?
For you, Mr. Chairman, that allowed this bill out, I will gladly yield.
Representative, is it not true that the intent of the language in this bill is to allow those school systems and those students to opt in, meaning that this is more of a may rather than a shall? Is that not true?
The gentleman knows when he speaks, it came in as a shall, it left as a may, it got a lot of massaging, and some of the kinks were taken out of it, and thank you for your help on the bill.
Do you further yield?
I'm getting to enjoy this, of course I will.
Chair recognizes Chairman Martin to your right for a question.
Can I rescind that?
Gentleman yield.
Of course I will, sir.
I resemble that remark, by the way, so if you rescind me. The serious question is, your intent is so students at a high school have the opportunity to take the test at their high school. Is that what you're trying to accomplish here?
That's exactly right, to include charter schools and juvenile detention schools.
My question, sir, is a practical matter, all of the students in a school don't choose to take the SAT or ACT at the same time, but instead take it at different times. Somebody may be ready in February or May. So exactly how would it work for a school if a high school in my district wanted to opt into this? Since these tests are given by a private company, they can't give the test every month at every school in Georgia. So how would this practically work so that we could implement it for our students? And I thank the gentleman for yielding. I'll wait on your answer.
Thank you. Based on what I've found out, these private companies will be glad to give the test whenever they get paid. So, you know, the tail isn't wagging the head here. The head is in charge, and the superintendents and the school districts will decide, and I'm sure these folk will be there for their check.
It's with great sadness that I let you know that there are no further questions.
Well, with great reluctance, Mr. Speaker, and I know you shall break down in tears, but I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. on the passage of House Bill 1184. The ayes are 166, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1482.
House Bill 1482 by Representative Irwin of the 28th and others to be entitled an act to amend Code Section 22-262 of the Official Code of Georgia annotated relating to low wealth capital outlay grants to local school systems and the criteria for eligibility. This bill having referred to the Committee on Education. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Irwin to present the bill.
Thank you, Mr. Speaker. I bring before you House Bill 1482. This will take a little bit of explanation. I'll try to go as quickly as I can. Capital outlay bill, and what capital outlay is, it is a grant program to allow K-12 school systems to access money for school construction. The program that we are addressing here in capital outlay is low wealth and low wealth project specific. And what we're trying to do with this language in this bill is allow more access to the low wealth and project specific money for the school systems of the state. Currently, and we're not changing it in law, the bottom 25% by SPLOSH collections of school systems in the state of Georgia qualify for the low wealth and project specific money. Currently, that is 44 school systems in the state of Georgia. These school systems need this money and access to this money because, I'll make an example, the lowest wealth school system in our state brings in a little over $200,000 a year in SPLOSH money. So over the course of 5 years, they will raise $1 million. They cannot build a school if they need it for $1 million in today's market. So what they can do is they can apply for low wealth money and project-specific money through the state for the grant, and what they'll do is they'll forfeit that $1 million, and the state has a grant program where they could qualify for up to $50 million to build a school. Especially these systems are also mostly rural, not heavily populated school systems in our state, so you could imagine they would build one school. Once they build that one school and they have applied for that money and received it, they cannot receive it again for 10 years. However, we realize that those school systems would not come off the list of the 44 bottom school systems in wealth in our state. So what we do through this bill is if you qualify for that money and get it and use the money, then you come off the list of the 44, allowing the 45th, 46th, 47th system to qualify and come on to that list and possibly access this money if needed. We also put that if you consolidate schools, that your school had to be a minimum of 35 years old that you are tearing down. With the materials that we use to construct schools today and the fact that we supply renovation money such as heating and air after 10 years, roofing after 20 years, that 35 became a good number that should be the minimum age of that school to tear down. So, Mr. Speaker, that's what this bill does and assists the low wealth school systems. Mr. Speaker, I will yield for any questions.
You have no questions.
With that, Mr. Speaker, I will yield the will and ask for your favorable consideration for the low wealth districts and the change in this bill.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 1482. The ayes are 169, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1515.
House Bill 1515 by Representative Bentley of the 139th and others to be entitled an act to amend Code Section 23411 of the Official Code of Georgia annotated relating definitions regarding tuition equalization grants at private colleges and universities so as to revise the definition of approved school. This bill having referred to the Committee on Higher Education. That committee recommends that this bill do pass.
Chair recognizes Representative Bentley to present the bill.
Thank you, Mr. Speaker and colleagues. I bring to you this evening House Bill 1515. House Bill 1515 will allow for institutions which was previously accredited by the Southern Association of Colleges and Schools, better known as SACS, that is now accredited by the Transnational Association of Christian Colleges and Schools, better known as TRACS, to be considered an approved school for purposes of tuition equalization grants. House Bill 1515 would impact only 2 schools in Georgia, and they are Morris Brown College and Payne College. And Mr. Speaker, I will yield at this time for any questions if anyone have any questions, but if not, I ask for your favorable consideration of House Bill 1515 to help the students at Morris Brown College and Payne College.
You have no questions. Let me repeat that. Now you do have a question.
I have a...
Do you yield for a question?
Yes, sir, I yield for a question. A question.
Chair recognizes Representative Maynor to your right for a question.
Thank you, Chair, and does the lady yield?
Yes, ma'am, I yield.
Morris Brown College is in my district, so thank you for bringing this to the floor. My question is, are the requirements for Southern Association of Colleges and Schools the same requirements for Transnational Association of Christian Colleges and Schools?
They are a little different because Morris Brown and Payne are both Christian colleges, you know, found off Christian values. So, yes. All right. Thank you, Mr. Speaker. No other questions. I will now yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Representative Howard rise?
Parliamentary inquiry.
State your inquiry.
I would like to acknowledge that Payne College is in my district, and I would like to let the author of this bill know that we do appreciate this bill and look forward to working with the track system.
All right. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 1515. The ayes are 167. The nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1187.
House Bill 1187 by Representative Williams, the 148th, and others, to be entitled an act to amend Code Section 4883 of the Official Code of Georgia, annotated, relating to exemptions from sales and use taxes, so as to extend the sunset of an exemption for certain high-technology data center equipment. This bill has been referred to Committee on Ways and Means. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Noel Williams to present the bill.
Thank you, Mr. Speaker. Colleagues, I rise today to bring to you House Bill 1187. This bill is for the high-tech data centers. We are extending the sunset to 2033, and basically what this bill is going to do is Georgia has become a mecca for high-tech data, and we are trying to incentivize and wanting to incentivize these centers to move to rural parts of the state. We're doing great in the Atlanta area, and we're wanting to move to some of the rural areas, and we're incentivizing these companies by doing so. And when we started out on this, the original was 2039, and we got it down to 2033. And there's some job credits, and this is a tax exemption, not a tax credit. So with that, Mr. Speaker, I will yield for any questions.
You do not have any questions.
Thank you, Mr. Speaker, and I appreciate your support on this bill. Thank you.
Clerk's office has just reminded me these bills are on the third supplemental calendar, and the bills are on the carts down front and in the back of the chamber for those of you who want to review them. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1187. The ayes are 153. The nays are 14. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1387.
House Bill 1387 by Representative Collins, the 68th, and others, to be entitled an act to amend Title 40 of the Official Code of Georgia, annotated, relating to motor vehicles and traffic, so as to provide for the suspension of a motor vehicle registration upon the failure to pay a civil monetary penalty for a violation of overtaking a school bus or speeding in a school zone. This bill having referred to the Committee on Motor Vehicles, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Collins to present the bill.
Thank you, Mr. Speaker. I bring before the House House Bill 1387. Several years ago, when the enabling legislation for the school cameras was put into place, the civil monetary penalty, if someone didn't pay that civil monetary penalty, it stayed with the vehicle. This was brought to my attention by several dealers in my area that had deals where they were traded in cars, and the dealer had to wind up paying the fee, the civil monetary penalty, in order to transfer the title. And we just felt like that wasn't very fair to the dealers, and so what we want to do is change in legislation that if the civil monetary penalty is not paid, the Department of Revenue will not allow that vehicle registration to be renewed. And then after June 30th, 2023, if that civil monetary penalty is not paid, after a series of warnings and notices, the registration will be revoked. That's the genesis of the bill, and very simple bill. I ask for your favorable consideration if there are no questions.
You have a question if you care to yield.
I'll yield for one since the hour is late.
Chair recognizes Chairman Parsons to your left for a question.
Thank you, speakers. Gentlemen, yield.
Yes, sir. Go ahead.
Thank you. That legislation you referred to actually was legislation that I had got passed a few years ago. But isn't it true? I'm trying to think this through. I think the reason that the way it is, it can be somebody's car, but somebody else is driving, and I think that's the reason that they're trying to. You can't with the video. There's no way to know for sure who's driving the car. Is that not true?
Well, I do agree with that, but I think there are a series of what ifs that could take place in the reasoning behind the situation that I've had to deal with dealerships in my area. Simply because you don't pay that ticket, whomever is driving that vehicle, the ticket goes to the registrant of the vehicle. So that person may or may not know about that. So this legislation will fix that. Local government, Department of Revenue will send a notice out and notify them that they have that civil monetary penalty. If it's not paid, it'll be won't be able to be renewed, or if it's not paid after July or June of 2023, the registration will be suspended.
Okay. Thank you. I appreciate your answer.
Yes, sir. Thank you. No further questions. I yield the well, and I thank the leader for his help with this piece of legislation, Mr. Speaker. Thank
Is there
you.
any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 1387. The ayes are 136, the nays are 29. This bill, having received the requisite constitutional majority, is therefore passed. The House, having reconsidered its action in failing to give House Bill 1424 the requisite constitutional majority earlier, the chair, that went back on the calendar, and since it's crossover, it will be called at this time. What purpose does Chairman Powell rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, is it not true that these machines that we're talking about, they're linked to the lottery terminal over to Lottery Central, and if we approve going to the gift card, then there'll be a direct link of keeping up with how much money is transferred through these machines.
If the gentleman so states, I'm sure he has studied the issue with great intensity.
Further parliamentary inquiry.
State your inquiry.
Is it not true that this bill and all of its intentions last year and this year has been to clean up this industry and to give folks a reason not to be paying out of cash? And if it's the intention of the good lady that has spoken about a tax, that perhaps she needs to place her own bill in to raise this tax and let it have a fair hearing through the normal process.
If the gentleman so states. What purpose does Representative Kirby rise?
Parliamentary
State
inquiry.
your inquiry.
Is it not true that while the Lottery Corporation gains some $145 million a year from these COAN games, we heard it compared to thoroughbred horse racing, where Keeneland Racetrack, the finest racetrack in the entire world located in Lexington, Kentucky, in the last fall and spring meet had a combined handle of just over $25 million. And even though they don't tax them at 20%, if they did, that would simply be about $5 million or $140 million short of what we're already getting from the COAN games. That a lower percentage of a bigger amount is a lot more money.
All right, let's do one or two more here. What purpose does Representative Stacey Evans rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true, Mr. Speaker, that we have all said in here that we are going to try to level the playing field between those that are paying cash, which encourages people to pay more by giving them the gift card? So the idea that this would make the revenues go down is exactly opposite of the argument for those that were proposing this bill. Isn't that true, Mr. Speaker?
If the lady so states.
Further, Mr. Speaker?
I'm sorry?
May I have a further inquiry?
Sure.
Isn't it true that throughout this debate, not one single person has told this body why we cannot have an increased percentage coming back to the Lottery for Education to support pre-K and higher education? And isn't it further true, Mr. Speaker, that I have advocated for a higher percentage and was told on multiple occasions that there would be one, and it is yet to materialize, and that is why I'm so adamant on this, Mr. Speaker, that we cannot give something for nothing. Isn't that true?
Well, I'm not sure what the lady was told, so I can't address that. What purpose does Chairman Carpenter rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that the fees collected from these COAN machines has actually doubled over the past decade, from a 5% now to a 10% fee?
I think that is correct. What purpose does Chairman Oliver rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true, sir, that the past negotiations on this bill, which has been bouncing around for a while, have almost always included an increase in the percentage coming back to the state? And isn't it further true, sir, in connection with these past negotiations, that I, not a naive person, have reasonable hope that as this bill moves forward, if the body chooses to move it forward, that we can have a continuing conversation about increased revenues to the state? Isn't that true, sir?
I'm sure it is true, Madam Chair. All right, let's vote it. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1424. The ayes are 100, the nays are 67. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1520.
House Bill 1520 by Representative Hawkins, the 27th, and others to be entitled an act to amend Title 31 of the Official Code of Georgia annotated relating to health so as to create the Georgia Council on Addressing Healthcare Workforce Challenges. This bill having been referred to the Committee on Human Relations and Aging, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Hawkins to present the bill.
Thank you, Mr. Speaker. House Bill 1520 creates the Georgia Council on Addressing Healthcare Workforce Challenges. As we all know, the state of Georgia has experienced significant challenges in hiring and retention of healthcare workers, including physicians, nurses, respiratory therapists, and others. This has been exacerbated by the COVID and has created a shortage of healthcare workers, which has a negative impact on public safety and access to health care. This council will work to support the expansion of education programs, will identify funding sources and loan forgiveness programs, will encourage investments in technology and workforce readiness, will improve retention and resiliency programs of healthcare workforce, and evaluate laws, rules, and regulations and policies. It will also create subcommittees to work simultaneously to look at rural healthcare advancement, hospital and healthcare systems, healthcare workforces, and so on. This council will be repealed on June the 30th, 2025. If there are no questions, Mr. Speaker, I will leave the well.
You have a question if you care to yield.
I'll yield.
Chair recognizes Representative Maynor to your right for a question.
Thank you, Chair. Does the gentleman yield?
I do.
Were you aware that over 90% of patients that are in the hospital because of the sedentary situation that they've been in, they need physical therapy as a result after that?
Yes. Yes, and this council will also look at that and look at the shortage of 28,000 nurses in the state of Georgia.
No further questions.
I ask for your favorable consideration. Thank you.
Gentleman has yielded the well. We have another member who wished to be heard, and the chair recognizes Representative Cannon to speak to the bill.
Thank you, Mr. Speaker. Hello, members. I am excited to speak in favor of this piece of legislation. You see, I rise in support because now we're talking about what really happened to our healthcare workers during the COVID-19 pandemic in Georgia, and I believe that's the right thing to do. I've heard from telemetry nurses, labor doulas, dietitians, clinical liaisons, and telephone triagers who have felt either ignored and left to fend for themselves over the past 2 years or overworked. And we need to hear from them because job scarcity happened, then emergency staffing shifts were held, then workers were told to go home, and then were incentivized with major hourly bonuses. Meanwhile, demand for healthcare services grew. We saw the statistics show that between February 2020 and February 2021, the industry in Georgia with the third largest job loss was health services. And it's important, I believe, that we use accurate data for action. The Robert Wood Johnson Foundation report on the Georgia Workforce Board website says a pattern of unfair differences exists for people with lower incomes and communities of color in access to care. Why would they say this? Well, when the Georgia Board of Healthcare Workforce announced its unexpected loss of its executive director, Ms. Hughes, in late 2021, many were concerned for her family and those were who supported by her staff. But also many were concerned what this meant for the data that would come out of the agency. I remember our committee heard from the Georgia Nursing Association and the American Nursing Association in November when they said that they actually have internal committees that discuss how race impacts healthcare provision in our state and how they wish they had more resources. So I hope that this piece of legislation passes unanimously, to be honest, because it's dire what's happening for those who are working and those who need healthcare access. You see, there are 75 counties with no OBGYN right now in the state of Georgia. There's 78 counties with no general surgery physician, and that's gone up since 2015. There are 54 counties with no emergency medicine physician, and some counties only have barely any resources. In the entire state of Georgia, there are only 19 pelvic medicine providers. Many people after childbirth see those. And there are only 130 neonatal/perinatal medicine providers. All I'm saying, y'all, is this is a great bill. I hope that you'll support it. Thank you.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1520. The ayes are 157, the nays are 10. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1283.
House Bill 1283 by Representative Douglas, the 78th, and others being entitled an act to amend Part 15 in Article 6, Chapter 2, Title 20 of the Official Code of Georgia, annotated relating to miscellaneous provisions under the Quality Basic Education Act, so as to provide for recess for students in kindergarten and grades 1 through 5. This bill having referred to the Committee on Education, that committee recommends that this bill do pass by committee substitute.
You still working on this, huh? How long? That's a long time for recess. Chair recognizes Representative Douglas to present the bill.
Thank you, Mr. Speaker. My colleagues, Speaker asked me how long I have been working on this. It's been a while. Actually about 6 or 7 years to get across the finish line. But I'm working off this substitute, and I just let everybody know how important it is for our youth. We did a lot this year for our teachers, giving them raises. That was well overdue. We had a lot about mental health this year. But if we don't take care of our youth, our tomorrow, we won't have anybody to give a raise to, and we will also help them in the healthcare department. So this is just the same simple bill. I just want to give my kids recess, 30 minutes, and not take it away for punishment. And Mr. Speaker, I just want to commend my education chair and vice chair for helping me change the language in this bill to help it be more palatable to get it across the finish line this time. So I want to thank them. And also, Chairman Houston, thank you for your kind words and helping me get this thing together. Thank you so much. If there are any questions, I will yield the will and ask for
You
your
have lots and lots of questions. Do you yield?
For one. For one.
For one.
For one.
Well, that makes me choose.
Oh.
I love doing that, though. Chair recognizes, let's see, who have I not called on? Representative Beth Moore for a question to your right.
Thank you, Speaker. Does my seatmate yield?
Of course.
Isn't it true that this body had the good judgment to pass your bill last year, as did the Senate? And isn't it further true that we're giving the governor one more chance to get this bill right?
The lady knows by what she speaks. I will yield the well.
Is there any objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Representative Al Williams rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I appreciate the gentleman's tenacity, and the first time he introduced this bill was right after I got out of elementary school?
What purpose does Chairman Setzler rise?
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Isn't it true if we pass this bill, we will make recess great again?
Mr. Chairman, I want you and Representative McLaurin just to go on over to the Senate, okay? Tonight, maybe. Wow. Have all members, what purpose does Representative Wilson rise?
Mr. Speaker, is it parliamentary inquiry? Mr.
State your inquiry.
Mr. Speaker, is it not true that we're going to build recess back better?
I'm not going to touch that one. All right. Have all members voted? If so, the clerk will lock the machine. On the passage of House Bill 1283, the ayes are 155, the nays are 12. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 937.
House Bill 937 by Representative Henderson of the 113th to be entitled an act to amend Article 7, Chapter 4, Title 49 of the Official Code of Georgia Annotated relating to medical assistance generally, so as to provide for Medicaid coverage for our annual mammograms at no cost to the recipient. This bill having referred to the Committee on Health and Human Services, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Henderson to present the bill.
Thank you, Mr. Speaker. Good evening to the House of Representatives. I finally made it. Colleagues, I stand before you to introduce HB 937. This bill has a personal value to me because I was diagnosed with a rare early stage of breast cancer 4 months ago. And I say rare because doctors at Cancer Treatment Center of America had not seen such an early stage in 20 years. However, after 3 months of treatment, last month in February, I rang the bell cancer-free. Thank you. Thank God. My bill adds a language that would require, because of that, requiring insurance companies to send notifications to women upon reaching age 40 to have an annual mammogram. And the reason I stand before you tonight is because at Cancer Treatment Center of America, I met a young lady, her name was Shelley. Shelley, a young lady, 43 years old, did not have a mammogram. She was cancer diagnosed at stage 3. The cancer spread from her breast to her liver, to her kidneys, and to her rectum. She was in a wheelchair with a colostomy bag. Shelley said to me, Miss Henderson, I heard you ring the bell, cancer-free, and I wish that was me. That was where I drew the line and started working on this bill. Women, make time to take care of yourself. Make time out of your busy work schedule, your busy life schedule with your family, and prioritize and get your mammogram. As we can see on the board, 9,000 in Georgia, 9,000 women will have to fight breast cancer this year alone, 2022. And about 1,400 will lose their battle to cancer. Those numbers are really excessively high. So therefore, I cannot leave this podium without thanking Leader Beverly, Chair Sharon Cooper, who worked tirelessly with me to make sure that we got this bill done. And last but not least, I thank God for my husband. Thank you, honey, for coming here. My first bill. Thank you for being here. This bill will allow many women to see sunshine and have a better life cancer-free. So I ask you to favorably consider this bill, and I yield back the well. With no questions. I'll make it easy.
Is there any objection? Thank you for no questions, by the way. I'll give you another bill later tonight if you want it. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no. And the clerk will unlock the machines. What purpose does Representative Anulowicz rise?
Parliamentary inquiry.
State your inquiry.
Does anyone know what happened to the fish? No idea what we're talking about.
I don't have it. That's all I know, okay? Just saying. My first bill is still out. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 937. The ayes are 170, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1034.
House Bill 1034 by Representative Wiedauer of the 119th be entitled An Act to Amend Code Section 4883 of the Official Code of Georgia Annotated relating exemptions from sales and use taxes so as to revise the exemptions for the sales of admissions to non-reoccurring major sporting events. This bill having referred to the Committee on Ways and Means. That committee recommends that this bill do pass.
Chair recognizes Representative Wiedauer to present the bill.
Thank you, Mr. Speaker and colleagues. I bring you House Bill 1034. This simply adds FIFA World Cup to the list of major non-reoccurring sporting events in which we offer a tax exemption, or sales tax exemption on the sales of just the tickets. It also extends the sunset of the provision that we already have in place. That is simply what the bill does. Mr. Speaker, I'll yield for any questions.
No questions.
Thank you. I'll yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of House Bill 1034, the ayes are 155, the nays are 15. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1533.
House Bill 1533 by Representative Newton of the 123rd to be entitled an act to amend Chapter 1 of Title 43 of the Official Code of Georgia annotated relating to general provisions relative to professions and businesses so as to provide that professional programs that are established to address career fatigue and wellness in healthcare professionals are not obligated to report licensing boards except in certain circumstances. This bill having been referred to the Special Committee on Quality Healthcare. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Newton to present the bill.
Thank you, Mr. Speaker. We've been discussing in depth a couple of things, mental health challenges, and we've been discussing healthcare workforce challenges. House Bill 1533 addresses career fatigue and wellness challenges for nurses, pharmacists, physicians, and other caregivers. Those have gotten so much worse during COVID and now the current staffing challenges that we're seeing. 1533 provides for establishment of a program in which individuals would have a confidential setting to help address their challenges, with a key point that as long as no patient or any individual were at risk. These are separate from board-ordered programs that are out there and available, separate from employer-sponsored programs that many people find themselves a little reluctant to use. This bill will help provide for early intervention, just like other preventive medicine health care, and will help keep our healthcare workforce strong and available for others. I hope you'll support House Bill 1533 to give this option for mental health coverage and career coverage for all our healthcare workers. With that, Mr. Speaker, I know the hour's late. I'll yield the will.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 1533. The ayes are 167, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 931.
House Bill 931 by Representative Cantrell of the 22nd and others to be entitled an act to amend Code Section 4324 and Chapter 5C of Title 48 of the Official Code of Georgia annotated relating to contents of certificates of title, certificates as evidence, and certificates not subject to garnishment or other process. This bill having referred to the Committee on Ways and Means, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Cantrell to present the bill.
Thank you, Mr. Speaker. Colleagues, this is a very simple bill. What it does is if a person who's confined to a wheelchair or has a dependent who's confined to a wheelchair, if they purchase a vehicle that's been converted to be wheelchair accessible, the cost of the conversion is exempt from TAVT tax. They pay the same tax on the vehicle, but not on the expense of the conversion, and that's all the bill does. Very simple, and with that, I'll yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 931. The ayes are 167. The nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. What purpose does Representative Bentley rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, is it not true that this bill is a great bill for all of the families and patients at the Shepherd Center here in Atlanta, Georgia? And for that reason, I was proud to vote yes for that bill.
I believe that it would be. Clerk will read the caption to House Bill 1350.
House Bill 1350 by Representative Wade of the 9th to be entitled an act to amend Article 1 of Chapter 5 of Title 53 of the Official Code of Georgia annotated relating to probate of wills, trusts, and administration of estates generally, so as to require executors to send notices to beneficiaries regarding the filing of petitions to probate wills. This bill having been referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Wade to present the bill.
Thank you, Speaker. Colleagues, this is a simple bill. Appreciate the opportunity to present it. House Bill 1350. This will just clean up some language to ensure that executors not only notify heirs upon the issuance of a will, but also any beneficiaries named. And we also add a little bit of cleanup language for the financial institutions in Georgia to clarify what security accounts under the Uniform Transfer of Death Security Registration. I don't think there's any need for questions due to the time. I appreciate favorable consideration. Thank you.
Is there any objection to the previous question being ordered? The chair hears none. Previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1350. The ayes are 169, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 424.
House Bill 424 by Representative Wiedauer and others, to be entitled an act to amend Chapter 7 of Title 48 of the Official Code of Georgia Annotated relating to income taxes so as to change certain definitions regarding such taxes and to provide an effective date and to repeal conflicting laws. This bill having referred to the Committee on Ways and Means, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Wiedauer to present the bill.
Thank you, Mr. Speaker. Here to present House Bill 424. Y'all, we've done a lot of great things over the years for kids in foster care, and a lot of times the kids that are aging out of foster care are the ones that are forgotten in this process. These children, I would suggest, are in the worst possible scenario when they age out and have no homes to go to. Fortunately, in the state of Georgia, we have great organizations like Lydia's Place in my hometown. These organizations are set up to provide and help these children that are aging out. Some quick statistics of kids that are aging out of foster care. Human trafficking victims have a 70% chance, or have a 70% of human trafficking victims have had a foster care history. 50% of kids born to teen mom in foster care will end up back in care. 81% of males, 57% of females have been arrested. 60% of them will be convicted. 71% of them will become pregnant. And less than 3 will ever go on to college. Less than 3% ever go on to college. This bill provides a new 100% Georgia income tax credit to support those youth that have aged out of foster care. Taxpayers can donate to organizations like Lydia's Place and provide assistance and mentorship to that aged out population. Credit is capped at $20 million per year. Y'all, this is a great measure, and I would appreciate your support for it. I'll yield for any questions.
Do you yield for a question?
I do.
Chair recognizes Representative Cannon to your left for a question.
Thank you, Mr. Speaker. Do you yield?
I do.
I want to thank you for this piece of legislation. I think other members will speak to this bill, but I wanted to drill down on how this impacts the work that DFACS will be doing on the daily. Can you speak a little bit more to how this actually impacts the agency and the work that they will be doing?
It would not directly impact the agency. What it would is for these children that have aged out of the foster care system. These kids end up with no homes, they end up with no families. These programs have targeted and watched for those individuals to come out that need that assistance. So this is a propping up of those children that no longer have that support. Mr. Speaker, with that, unless there's other questions, I will yield the well. Thank you.
Gentleman has yielded the well. We have another member that wishes to be heard. Chair recognizes Representative Erica Thomas to speak to the bill.
Thank you so much, Mr. Chair. This is a really good measure, and I'm excited to speak in favor of this bill. Hundreds of kids age out of the foster care system every single year. 51% of those children are not children, adults are unemployed, and 43% end up homeless. A lot of kids don't know until their 18th birthday when they find themselves homeless or their clothes outside of the home that they saw as home for maybe years or months before. And so we help these children up until they age out of care. And it is a huge fiscal note to helping these children every single day while they're in care. And then when they age out of care, we see them left dissolute. And when I say that, a lot of these children don't know a lot about financial stability. They don't know how to write a check. They don't know how to start a bank account. They don't know how to pay rent. They don't know a lot of things. And so we have so many different organizations in the state of Georgia that are tasked with the care and trying to help children with financial literacy. And I keep saying children, but a lot of these kids and people that are aging out of the care are not children. They're 18, they're 21, they're 23, and they don't know how to write a check. Can you imagine not knowing how to write a check, how to balance a checkbook, how to pay your rent, or things that normally our mother and our father would teach us to do? And so we have amazing organizations that help these children to learn how to be stable adults. And with this bill, this would help organizations just like the representative spoke about, and giving them a tax credit, putting money into funds to help these children to be stable adults. We always talk about being proactive and not being reactive. And this bill is helping us to be proactive. Because let me be real with you. If these kids don't know how to balance a checkbook and don't know how to be stable, they will end up at your door. They will end up in the street. They will end up robbing and stealing and killing. And this is what we are trying to prevent by helping them to age out sufficiently to be stable adults. And so I ask you tonight at 9:33 p.m. to vote in favor of this bill, not only to just help these foster kids, but there are thousands of foster students in your district that would benefit from this bill. I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no. And the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 424. The ayes are 166, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1405.
House Bill 1405 by Representative Roberts, the 52nd, to be entitled an act to amend Title 36 of the Official Code of Georgia Annotated relating to local governments, so as to revise the zoning procedures law and to revise provisions related to judicial review of zoning decisions. This bill having referred to the Committee on Governmental Affairs, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Representative Shay Roberts to present the bill.
Thank you, Mr. Speaker. Colleagues, I present to you House Bill 1405. I'm not going to say this is a simple bill, but I will say that it will simplify things. So it amends the Georgia's zoning procedures law to codify the process and procedure for challenging and appealing certain land use decisions. Land use cases are essentially divided into two categories: legislative and quasi-judicial. This bill codifies which types of cases fall under that category and the process that should be followed for each. Legislative decisions, just for an example, would be a rezoning application. If a developer wanted to put in a subdivision on an agricultural property, they would go to the local legislative body, the county commissioner, city council, and that would be a legislative decision. Up until 2017, the law was clear that when you challenge that decision, it's by de novo, meaning that you get to present new evidence, a full trial before the Superior Court judge. If you've attended a zoning hearing in your local jurisdiction, you know that typically the applicant and the opposition only get 10 minutes each to present their case, and so it would be impossible to put on a full evidentiary hearing in that time. So basically this bill, as related to legislative, will codify that it is by de novo review. That's been the law for 40 years, common law for 40 years. But there were some Supreme Court cases in 2017 that had overly broad language. And what that has resulted in is that the public and the lawyers that represent them and the counties are basically having to prepare cases two different ways, and it gets really expensive and the resources are stretched. So, and the second piece is it clarifies the certiorari process, which is the quasi-judicial variance. Those are decided only on the evidence before the zoning review board. And so those are technical, and if you make a mistake on the requirements, it's dismissed immediately. It's not amendable. And one of the things is it's hard to reach a county person to get service, so the local governments are going to have to amend their zoning ordinances to designate someone that's available to help the public meet these requirements. Okay, I can tell I'm boring y'all to death with this legalese. So, let me get to the good part. There is no opposition. ACCG, GMA, Georgia Realtors, we all work together on this bill, zoning lawyers, and there is no opposition. They've all given me express permission to say they're in favor of it. So I would ask for your favorable consideration now that I've given all that legalese.
Do you yield for questions?
Sure.
Chair recognizes Representative Washburn to your left for a question.
Thank you, Mr. Speaker. Will the gentlelady yield for
Yes,
a question?
I will.
Is it not true that this bill will clarify the whole zoning appeals process and clear up a lot of confusion?
That is correct.
And will you yield for another question?
Yes, I will.
Is it also not true that it will be much less expensive in order to appeal a zoning decision?
For the citizens and the local governments as well. Thank you for the question. I think I'm going to yield my time.
It's up to you.
Everybody wants me to get gone. I yield.
Lady has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Chairman Blackman rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that this is Representative Roberts' first bill?
It is, I think it is, but we don't have the fish, I understand. Good job. Have all members voted? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1405. The ayes are 160. The nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1382.
House Bill 1382 by Representative Stevens of the 164th and others to be entitled an act to amend Code Section 3662A 21 of the Official Code of Georgia Annotated relating to required training on development and redevelopment programs so as to require directors to do yearly continuing education. This bill having referred to the Committee on Governmental Affairs, that committee recommends that this bill do pass.
Chair recognizes Chairman Stevens to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 1382 is a continuation of two measures that came out as a recommendation from the Rural Development Council. As you might recall, earlier we did one of a continuing education for water and sewer authorities of 4 hours continuing education. This one here does 8 hours for the first year. Thereafter, it will be 4 hours as the other one did. This will be required, of course, before you can get One Georgia Authority money. I'm going to recommend to the Senate, once it gets over there, they potentially combine these two bills. If there's no questions, I'll yield the well.
You have no questions. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 1382. The ayes are 162, the nays are 4. This bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to House Bill 1464.
House Bill 1464 by Representative Gunner VIII and others to be entitled an act to amend Article 1 of Chapter 3, Title 35 of the Official Code of Georgia Annotated relating to general provisions regarding the Georgia Bureau of Investigation so as to provide the Georgia Bureau of Investigation with original jurisdiction to investigate election fraud and election crimes.
Chair recognizes Chairman Gunter to present the bill.
Thank you, Mr. Speaker. Members of the House, House Bill 1464 affects more the election process than anything else. Does not affect an individual's ability to vote, and for the most part, this is a cleanup bill. I want to run through each of the sections, and starting with Section 1 on to page 3. This has to do with the receiving a grant, gifts, or donations. They will all be sent to or controlled by the state election board, and it will make the distribution and decision what happens with the donations. On to page 4, lines 80 through 83 specifies the local election officials to be appointed to the Performance Review Board. In Section 3, again, this has to do with the grants and gifts given, and it's basically the same scenario that it goes to the state election board. Section 4, this allows the folks working in the election to not have to go through all of the machines. As the early voting goes, they can take the count of the people that have voted, and it's still a ratio of 250 electors to one machine, but they reduce the number by those that have already voted. So it makes it easier for the election officials so they don't have to go through and test or set up all of those machines. Let's see, Section 5 over to page 8. The only change there is the wording of the notice in the message to the voter. If you're sending out absentee ballot application, you have to have this wording on it, and it's just a change in the wording. It basically says the same thing, but they reworded it. On the next page, Down at the bottom, 224, 225, this clarifies that all persons or entities that mail unsolicited applications for absentee ballots to electors in the primary election or runoff shall mail them only to individuals who have not already requested, received, and voted an absentee ballot in the primary or election. On to page 10, down in the middle in this section, you can still produce blank absentee ballots, absentee ballot applications, and make them available to electors. So if you're somebody that's in that business, then you can do that. Section 6 was basically repealed by Senate Bill 202 with the ranked choice ballot. So this basically just takes out Section B, which required a write-in absentee ballot to be included with the absentee ballot sent to the elector. At the bottom of the page, this requires that drop boxes are kept in the like in the office of the Board of Registrars, the absentee ballot clerk, or inside locations where there's early voting. When all of that activity comes to an end in the day, the drop boxes are then locked. Before, I think it was closed is what it said, but now they're locked. All right, next page, page 12. This has to do with the ballot transfer form. Collection of the drop box ballots into a transfer case, which is locked and sealed. That's basically what that is, and it sets out the form, or that the form will be on there. Much of this bill has to do with sealing the ballots or the chain of custody of the ballots. That may sound like a big project to do, but really it's quite simple. When I was district attorney and we dealt with evidence in cases, and those of you that out there that have practiced criminal law understand this, you attach a sheet to either a bag or to a box, whatever the evidence is in. And it's just a sheet of paper, and every time you transfer it to someone else, there's a sign off. And that's basically all it is. It's pretty simple. And that's what several of these sections in this bill require, is it sets up this chain of custody and how you're to use that. Let's see, on to all of this up through where I was at to now I'm on page 17. All of that has to do with the chain of custody. On page 17, it requires that 3 persons are to be present at all times while the absentee ballots are sealed in containers then they are unsealed, and while the ballots are being opened and scanned. Okay, let's see. On page 19, at the conclusion of the scanning, the ballots are then sealed in a container, and the transfer forms or the chain of custody forms are to be filled out. Let's see. All right, on to section 9. This is really a bill that was introduced earlier that we combined into this one. This has to do with employers allowing time for their employees to go to vote. And it's a scheduled time. Lisa Hagan, I believe, is going to come up after me, and she can explain this in more detail, but that's basically what that does. Let's see. Poll watchers. Next is the next section. That has to do with if the party or the political body has a candidate on the ballot, they can have a poll watcher at the poll. All right, on to page 27. This is all in the same section. In this, it reads, as described in this code section and subject to reasonable regulations to prevent overcrowding and interference with official duties, certified poll watchers shall be entitled to meaningful access to polling places, advanced voting locations, tabulation centers, and locations where absentee ballots are being verified and processed. So So that's basically what that one does. Then on to section 11. This has to do when a person casts a provisional ballot and then where those go and that they're sealed. Again, this comes out of a bill that Alan Powell had, and he may be speaking on this as well after I'm done here. On to section 13, lines 775 and 776. We struck the first sentence out there regarding counting the number of ballots cast at the polls. In talking with the Secretary of State's office, this was taking too much time on election night, so we're striking that out and taking that burden off of them. And basically, they already have the numbers on the absentee ballots or advanced voting ballots. Section 14, this has to do with the consolidated return of the primary, and section 15 has consolidated return of elections. We just took the term sealed out of it so that when the documents are turned over to the clerk's office, they don't have to be sealed. That's basically all that says. Section 16, when everything is said and done with the election, the ballots are all compiled together and all the other documentation for the election, it's all boxed up and sent over to the clerk's office where they hold it for 24 months. And then they bring it to the grand jury after 2 years, and those documents are then, at the approval of the grand jury, destroyed. And that's basically what this is talking about. Section 17, in Section A, it defines the term acts in a manner other, in any other manner to intimidate. And then on the B section, uses that term in detailing out the crime of threatening or interfering with an election, and it's a felony. All right, and section 18, in this section, this gives original jurisdiction to the GBI in order to investigate or identify violations of the election code, basically. And what that is they can investigate, but they're working under the control of the State Election Board and the Attorney General's office. In section 19, that is their subpoena power, but it has to be through the approval of the Attorney General's office. And that is basically the bill, and I'll take any questions if anyone has any at this time.
Do you yield for questions?
Yes, sir.
Chair recognizes Representative McLeod to your left for a question.
Does the gentleman yield?
Yes, ma'am.
Is there a fiscal note for this bill?
No.
Does the gentleman further yield?
Yes.
Are the county Board of Elections supervisors in agreement with this bill?
I don't know. I know that some of them spoke at the committee hearing and some had criticism of the bill, things that they would like to see changed, but no strong opposition to the bill, I'll put it that way.
But there was criticism.
There was criticism of some things in the bill, yes.
Thank you.
Do you further yield?
I do.
Chair recognizes Chairman Efstration to your left for a question.
Does the gentleman yield?
I yield.
Sir, isn't it true that a chain of custody document allows anybody who touches something to be recorded on that document, so that if later there's a question as to how that, say, you mentioned in a criminal case in that context, who had that evidence, who tested that evidence, who opened it, all that's documented so it can be reviewed later. Is that correct?
That is correct.
Isn't it true that in the court judicial context, criminal cases, as you mentioned, that's incredibly helpful? In fact, it's necessary if you got a case to present in court, you can actually call the witnesses who touch that evidence at each stage in the process. So if that's to be reviewed, there's that complete history, and you have that documentation through
Right.
the chain of custody record.
Right. It makes that evidence reliable to be introduced in a court.
Thank you.
Yes, sir. With that, I know the hour is late, and I'm going to yield the well and ask for your favorable consideration.
Gentleman has yielded the well. We have a number of members who wish to be heard on the bill. The Rules Committee has set a 1-hour time limit, with that time to be allocated by the chair, and it will be divided equally between both sides to be used as the members see fit within the group. Chair recognizes Representative Paris to speak to the bill.
Thank you, Mr. Speaker. Colleagues, today I rise before you in opposition of House Bill 1464. This bill is the majority party's least attempt to rush an anti-voter bill through the legislature. This bill will devastate local election administrations. This legislation also harms our election systems in numerous ways, but what stands out to me most is the way this legislation attacks election workers and election administrations in Georgia. Who votes is very important, but just as important as who votes is who counts the votes. Currently, our state does not give counties all the resources they need to fully and properly fund elections. So counties have to apply for grants and seek out donations. This is a system that works and has been a lifesaver for counties all across our state. These grants and donations were a lifesaver in 2020 for the election offices in my home county of Macon-Bibb. But it's not just my county that benefited from these grants and donations. The representatives from the 24th, the 25th, the 8th, 18th, and 9th districts, and so many more all represent counties that benefit from these election administration grants and donations. But now, here we are, and the majority party is trying to prevent our election offices from directly receiving grants or donations for any election administration related purposes. So instead of the people who know their county election needs best being able to address those needs in a tried and true way, the state election board will have the centralized power to decide what all of Georgia's 159 counties need. Hence, this puts more cost on the county and their taxpayers. In practical terms, so currently, if a church wants to donate their space to a polling location or donate food and water for voters, they cannot. The church would have to file an application with the state election board and pray their grant will be requested. And pray their request will be granted. How about that? We're creating more red tape and further hamstringing counties and our election workers, when all they've asked for from us is for our help and our support. But that's clearly too big of an ask for the majority party. Losing elections or the threat of losing power is not a valid reason to change the rules. The wants of conspiracy theorists is also not a valid motivation to change the rules either. So I'm asking each of you to stand with Georgia voters and to stand with our hardworking election workers and to vote no on House Bill 1464. Thank you, Mr. Speaker, and I yield the well.
Chair recognizes Representative Dreyer to speak to the bill.
Thank you, Mr. Speaker. I rise in opposition to House Bill 1464. I want to start with a question. Do you remember where you were on September 11th, 2001? You remember the room you were in? A lot of you were right here. You remember the first plane that hit and the second plane that hit and when you knew it was a terrorist attack. Do you also remember where you were on January the 6th, 2021? because it's the same. I remember exactly where I was. I was at the Fulton County Tabulation Center because that was the day the absentee ballots for the Senate runoffs in Georgia were being tabulated. I got there at 6:30 a.m., and there was a room that at the Georgia World Congress Center that was probably at least 10 times the size of this room. It had been set up so that the public, not just poll monitors, could access almost the entire area and come within about 6 feet of everything that was going on. On one wall, there was media from all over the country. And when I got there, I found there were poll monitors from all over the country too. They were officially credentialed Republican poll monitors from places like Illinois, Florida, and Minnesota. A gentleman from Illinois who was a Republican credentialed poll monitor kept getting in trouble because it was in the middle of the pandemic and his mask kept falling down, and he kept trying to get to an area where he could look at data that would identify a voter next to their ballot, okay? That guy, at one point, as he was debating one of the poll supervisors, said, "There is no law, only opinion." I wrote that down in an affidavit that I have in front of me because that guy and some national groups filed a lawsuit claiming there wasn't enough access to the voting tabulation that day. There was a poll monitor from Florida, Republican credentialed, who said in loud voice so that everyone could hear, "Doesn't matter what happened, there's no way these results are going to be accurate today." She said that at 7:30 a.m. that morning. Over and over again, I kept running into people with an agenda that had flown to Georgia because they had been misled by their leaders, and they were espousing conspiracy theories, and it was interrupting the orderly processing of the absentee ballots. It got so bad that at about 12:30 p.m., and that's an important time, at 12:30 p.m., about 6 dudes showed up, and I say that because they were wearing heavy metal shirts. They were about 25 years old, and they had photocopied a Republican election monitor credential, and they tried to get into the secure area, okay? They were fortunately turned away, but right about 12:30 p.m. to 1 p.m., the former president instructed the crowd that he was talking to march down to the U.S. Capitol. And I remember how that ended up. We have a provision in here that says the same thing that I kept hearing all day. We need to have meaningful access to view the voting tabulation. But I want to be really clear. You could see everything that was happening, but some areas you had to view it, if you were a member of the public, from about 10 feet away, maybe 15. If you were a credentialed poll monitor, you had to view it from about 5 feet away. And why is that? Because the Georgia Constitution provides that our vote is secret. No matter what we do, the Georgia Constitution provides that our vote is secret, and that is a principle of a democracy. But that wasn't good enough. The folks kept wanting to get back into the area because if you turn in your absentee ballot, you sign it on the outside and it's got other identifying information. The place they wanted to get was the one place where there wasn't vote counting being done. It was when an envelope was opened, the ballot was removed from the envelope so you could see someone's preferences and you could see their name side by side. And I could see everything going on because I was only 5-6 feet away, but I couldn't see their name, but that wasn't good enough. So the national group filed a lawsuit, and then they filed a motion for contempt, and I had to testify in court because Fulton did everything they were supposed to do that day in spite of all the disruption. I mean, there might be some disagreement in here, because I just heard it, but we haven't seen it. Our Senate runoffs were conducted well. And while I'm down at the voting tabulation center and I'm hearing things like there is no law, there is only opinion, when I see guys in heavy metal shirts walking up trying to get into the area that only Republican and Democratic credentialed poll monitors could get, in the United States Capitol, when they were trying to certify the presidential election, there was an attempted coup and a violent insurrection. September 11th was a wake-up call to this country. I think everybody in this room on January 6th thought it would be a wake-up call. I hope everyone in this room believed and wanted it to be a wake-up call. It hasn't been a wake-up call because we continue to enact laws based on the lies that led to the violent insurrection in the Capitol and the continued assault on democracy. And we are part of the problem, if that's the case. We are chipping away at democracy. We are chipping away at what has made this country a leader in the world. And when we lose our moral mandate, it will never come back. When we fall from democracy to authoritarianism, we will not get it back because it has never happened in the history of the world. We can do better. We should be better today. We can turn the corner, and I want to ask if you would just take a minute and think of where you were on January the 6th, 2021, and what you hoped would change because of that event, and know that you have the power to do something about it right now. I yield the well, Mr. Speaker.
Chair recognizes Representative Mallow to speak to the bill.
Thank you, Mr. Speaker. Colleagues, I rise before you today to ask you to oppose House Bill 1464. There are a number of dangerous and harmful provisions in this bill, but I'm going to focus on one that sticks out to me especially that is very concerning. House Bill 1464 seeks to give the GBI sweeping new powers over our elections in this state. The use and threat of law enforcement intervention related to elections isn't something that is new and is not conjecture, and that the involvement of law enforcement can and has been used to intimidate voters, especially those voters of color. Now, you may think that is not the case, but for the constituents that I represent, that is very much a reality because they have lived through it. If you don't believe me, I encourage you to go talk to the gentlewoman from the 165th House District who has led civil rights demonstrations all over this state, and I'm sure you can have a conversation with her and she can educate you and school you. By giving the GBI, the state's highest law enforcement agency, original jurisdiction over election investigations, members of the majority party are doubling down on voter suppression. Now, some would have you believe that this is not the case, but this practice dates back not only to the Jim Crow era and beyond, but under this chapter, this is another attack on the right to vote. I bet there's an even more example, more recent today that I'm going to talk about, and today I'm going to tell you a story that goes just back 12 years and took place in a county named like so many counties in our state after an ardent and violent racist in Brooks County, Georgia. So what happened in Brooks County in 2010 is the perfect illustration of how the majority party has used law enforcement to suppress and intimidate black officials and voters, and it's a perfect illustration of the majority party's motives with House Bill 1464 and giving the GBI sweeping new authorities over our elections. In 2010, we saw a blatant act of voter suppression and intimidation after 3 black women got elected to the Brooks County School Board, and their election flipped the school board from majority white to majority black. And after their elections, they were arrested. 12 black people in total were arrested under the direction of the Secretary of State, who was Brian Kemp at the time, and these 3 women and 9 of their allies and friends were all arrested, and they were charged with 120 counts of voter fraud. And what truly was their crime, as far as I know, it's not a crime for black people to get elected to office and to make their voices heard at the ballot box, although in this state it might seem hard sometimes. The election of these black community members and educators to the Brooks County School Board did not break any laws, but it upset the power structure that existed in Brooks County, which was enough motivation for the Secretary of State and state officials to send the GBI to investigate it, and it was even more motivation for the DA at the time to vow to prosecute these individuals even without hearing any evidence or having any hard evidence of any wrongdoing. Even after devoting extensive resources to this quote-unquote investigation, all the charges were dropped. I'd like to make a juxtaposition here that these folks were arrested in Brooks County quicker than the folks who had killed Ahmaud Arbery were arrested and prosecuted in Glenn County, Georgia. But the one thing about this case of extreme voter suppression that sticks with me are the words of the GBI director at the time. He said, and I quote, "It's really extraordinary that the GBI would conduct voter fraud investigations," end quote. The GBI conducting voter fraud investigations is extraordinary. Let that sink in. It's unusual. It's remarkable. It's unbelievable. So why is the majority party trying to pass a bill that would give the GBI original jurisdiction to do just that? Well, the majority party will say it's all about preventing voter fraud, and that's exactly what Brian Kemp and others would like to say happened in 2010 in Brooks County. But it's just not the fact. This provision in House Bill 1464 will be used to intimidate Georgia voters and election workers. It's also that this is unnecessary. The State Election Board already has the power to investigate alleged violations of our election laws under OCGA 21-2-31. We very clearly do not need this bill. My colleagues in the majority party and in the minority party agree that our most recent elections have been the safest and the most secure elections we've ever had in this state. So I ask the question today, why are we doing this? The people of our state have so many important needs, and we as the legislative body have the power with the stroke of a pen to change the lives of countless Georgians for the better, but instead we're using them during this time to pass a harmful and unnecessary voter suppression bill. But we all know the truth. We're wasting our time on this bill. The truth is that after record turnout amongst voters of colors that flipped Georgia blue and sent Senators Raphael Warnock and John Ossoff to D.C., we see that folks in the majority party are doing exactly what they've done before, using any means necessary to hold on to power. And we all know that while we're seeing another bill attacking our election system and our election workers in the state of Georgia, it has nothing to do with election integrity or security. This bill is about the majority party legislating on the lie, the big lie. But I'll leave you with this as I close. Something we've all heard before, and my grandmother used to say this: a lie don't care who tell it. So I'm asking each of you to stand on the side of truth, and the truth is this bill is unnecessary and it's dangerous and egregious, and I'm asking each of you to please vote no on House Bill 1464 so we can focus on bringing real solutions to the real problems that Georgians face every day. And with that, Mr. Speaker, I yield the well.
We have other members that wish to be heard on the bill. The chair recognizes Representative Lisa Hagan to speak to the bill.
Thank you, Mr. Speaker. I take voting very seriously, so I thank everyone who has worked hard on the various parts of this bill to make sure we continue to improve our elections process so that it is fair and secure for all Georgia voters, and that is why I'm supporting it. House Bill 1464 is almost 40 pages long, but I'm here to speak tonight to just one section, and that is Section 9. There's been a lot of talk about what some people don't like about this bill, but there's bipartisan support of this section, and I think that it's worth pointing that out. Currently, an employer must permit his or her employees to take time off to vote on primary or election day only. This change simply says that an employee may vote either on primary or election day or on one of the early voting days. So it's that simple. It takes pressure off an employer to have all their employees leave to vote on the same day. It increases voting opportunities for working Georgians. It encourages in-person voting, which is the most secure way to vote. This bill ensures that ballots will be more secure. It clearly defines the chain of custody of those ballots. It reduces the chance of private money influencing our elections. And it expands voting opportunities for Georgia voters. So I hope you will join me in voting yes on this good bill. Thank you, Mr. Speaker, and I yield the will.
Chair recognizes Chairman Alan Powell to speak to the bill.
Thank you, Mr. Speaker, and ladies and gentlemen. I like Ms. Hagan. I want to address one part of this bill. You know, early in the session, I passed a bill out of the committee, 886, and this was the chain of custody. And that's one of the parts of this bill that I'm going to address. Passed early on, it's been held, but this came to me from a lady up in Hart County. And you know, I want to tell you all that sometimes some of the better ideas, we think we can be so smart in here, but some of the better ideas that we get comes from constituents that actually sit back and they watch and see what goes on. But I've got a lady, her name's Dana Smith, and you know, she's actually such a nice lady because she's the only person I know that says okie dokie instead of what some of the language that some of us use down here. But she was watching last year when we were doing the election reform bill, and she came up with this idea that because of the animosity in the 18 and the 20 elections, that there was something that was lacking as far as trying to bring some feeling of the public that our system was being worked right, and one of those was chain of custody. If you go through this bill in sections 8, 11, 12, through various sections, you'll find a prescription for chain of custody. And that chain of custody is tamper-resistant boxes with a chain of custody form, some with seals, and it'd be recorded so that the public and those investigators would know who's been in these boxes. And when I say it goes through the whole system of the election, it goes through the part where the security paper from the point of delivery to the elections polls, to the drop boxes, from picking those ballots up from the drop boxes, to the absentees, to the scanned ballots, to the provisional ballots, to the tabulated ballots. So this would basically put a chain of custody. Now last year, you know, when the election reform bill was passed last year, I said this then and I'll continue to say it now, that yes, there's so much distrust in our society today and in the political parties. But I would like to tell you that the only way that we can do away with that is by putting absolute, irrefutable truth in how an election is being run, so that everybody, no matter what your political party is, so that you can see and to verify that things are being done and reported accurately. That's what this bill does. And that's what this chain of custody language that's in here does. And for that, I want to thank you for those of y'all who will consider to vote for this. And I'm not up here to try to stir anybody. I'm not going to get a pitch in a fit about anything. But listen, this is something that helps us to set the rules of an election, no matter whether you're in Hart or Fulton, Franklin or DeKalb or whatever, so that the rules of operation are the same no matter where you go. And this chain of custody is a valuable part of doing that. And that, ladies and gentlemen, is my piece to this, and I would certainly appreciate your support for this bill.
Chair recognizes Chairman Knight to speak to the bill.
Thank you, Mr. Speaker. I'll be brief. You know, I'm not worried about where I was in January. I'm trying to remember where I was on November 3rd of 2020 when Representative Mathiak called me up. In Spalding County, every precinct, every voting precinct, every poll did not work. And every voter that showed up that morning was sitting in line because of a supervisor, election supervisor, who failed to train, but not only failed to train, had no idea of emergency procedures. We didn't have the required number of ballots, absentee ballots, or even provisional ballots at the polls that day. So guess what? She started copying ballots and started just sending them out in paper boxes via county workers. Nothing secure. Nothing. Later on that day, she called people in and said, go pick up the provisional ballots, which should have been emergency ballots that day, and bring them back in. Anybody knows that's against the law. So guess what? She sent people out to the polls because the secure boxes were running over, and people were walking out of a Spalding County election polling places with paper boxes of voted ballots. Voted ballots. It's against the law. There was no chain of custody. There was no security. And then she got those ballots back, which should have been emergency ballots, and scanned in through the machines, and it took 2 days to go through and adjudicate those provisional ballots, and nobody knew what was going on. You want pictures? I got pictures of where all these returned ballots or just blank ballots are just sitting all over the offices. This is real. This isn't D.C. This is right here in Georgia. This was right here in our county. As an old auditor, chain of custody is important. There was no chain of custody. How can you have chain of custody when ballots were taken out of the polling precincts and there was no documentation? They never should have been allowed out in the first place that day until the polls closed, and they did a complete reconciliation. This is one of the most needed pieces of legislation, and if you don't believe it, you go look at what happened in Spalding County. It's a travesty. I want to applaud the author and everybody who worked on this. This is about the integrity of the elections. And I don't care what party you're from. I don't care how you vote. It's about the integrity of the elections such that everybody knows that the procedures are followed and the rules are followed. And if they're not, we get to look at it from an investigative point of view and make sure that we keep up with the integrity of elections in Georgia. Thank you to the author and everybody who worked on the bill. Much, much needed legislation. Thank you.
Chair recognizes Chairman Burchett to speak to the bill.
Thank you, Mr. Speaker. Colleagues, we were doing so good today. I mean, we were all in here singing Kumbaya and getting good bipartisan bills put together, and you know, we're going to end on this one. I really believe that this bill, the only reason that is contentious is because it's in Title 21. This bill does nothing more than add administrative provisions to allow for chain of custody, tracking of bills. These are processes that are already in place and that we're already doing in the majority of the Board of Elections and Board of Registrars. These are the things that are already happening. We're codifying and coming up with a uniform provision for that. That's what I believe that we're doing in this bill. This is a very good bill. I understand that some of my colleagues, are sort of beating the war drum on elections here, but this is a good bill. This does good. This has measures that broaden the ability for voters to go to the poll. For the first time in the history, as Representative Hagan mentioned, we're allowing voters to take off for early voting. That's never been done, but nobody gets up there and talks about this piece. The GBI, original jurisdiction. The GBI has been investigating elections for years. The only provision that changes here is they don't have to be requested by the Secretary of State or any local government. And if we can't trust the highest law enforcement agency in the state, who can we trust? Do you want to have cyber ninjas come in here and work on your elections? Is that what you want? That's not plausible. Please, 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 please. I know I'm not changing any minds up here. I don't believe I am changing any minds. But I do want to say that these are good measures, and the only reason that my colleagues are up here adamantly opposing these things is because it's in Title 21. It's in the Elections Code. That's it. I want to run through a couple pieces here. One of the presenters had mentioned something about gifts to voters, and this does nothing to restrict gifts to voters. Doesn't change anything whatsoever about folks in line. This does nothing. It does not change that anywhere in the bill. Show me where it does that. Show me the suppression of the vote. Show me where it's driving people away from the polls. It's not in the bill. Just read the bill. Read the bill, read the words on the page, and read them for what they do, not what you think they do. I'd appreciate you voting with me on this bill in support of House Bill 1464, and I yield to Will, Mr. Speaker.
That completes the members who wish to speak to the bill. Is there any objection to the previous question being ordered? Chair hears none. The previous question is ordered. We do have a minority report, and by House rule, that will be limited to 20 minutes. 20 minutes for the minority report. Representative Nguyen, are you beginning? Chair recognizes Representative Nguyen to speak to the minority report.
Thank you, Mr. Speaker. Last legislative session, the majority party passed a massive voter suppression bill, and we quickly saw the fallout from Georgians all across our state and from the business community. Members of this body insisted that that bill would not make it harder for Georgians to vote. But now, guess what? We have some evidence. During the 2020 municipal elections, Georgia voters were 45 times more likely to have their applications to vote by mail rejected. And for those Georgians who were actually able to receive a ballot, their ballots were twice as likely to be rejected under Senate Bill 202. And here we are again. The governor promised no new election bills. And now we've got a 40-page bill shoved through committee, fast-tracked onto the House floor, and just like Senate Bill 202, a bill predicated on lies, misinformation, and conspiracy theories. This time around, we're attacking our election system, and we are directly targeting our election boards and our election administrators who have continued to work on behalf of Georgians despite the unfunded mandates, despite the intimidation, and despite the harassment. Every single member of this body should do everything in our power to ensure our local election boards have the adequate resources to carry out free and fair elections. But this bill does the opposite. We're now forcing our local election boards to jump through unnecessary hoops to receive private grant funding under the guise of so-called partisan advantage. And now, our local election boards will be forced to rely on a partisan state board of elections to either approve or deny that source of funding. To suggest that private funding provided a partisan advantage is simply misleading. I want to be very clear. In 2020, all 159 local election boards had the opportunity to apply for grant funding. Some counties chose to apply, others did not. Both Republican counties and Democratic counties received over $40 million to purchase more equipment, to provide hazard pay for poll workers, to purchase more drop boxes, to add additional early voting locations. Cherokee County, Lowndes County, Forsyth County, Paulding County, Gwinnett County, Fulton County, Muskogee County. I want to also be clear. The funding was not just so-called liberal Zuckerberg money. It was also so-called conservative Arnold Schwarzenegger money. So I want to get this straight. All 159 counties eligible to apply, both Republicans and Democratic counties received so-called liberal and conservative money, no instances of impropriety, and now we got to pass a bill that allows a partisan board to decide who or who should not get grant funding. And on top of that, this bill is full of unfunded mandates that will increase the workload on our election workers, many of whom already want to quit. 1 in 5 election workers on both sides of the aisle, they want to quit before 2024. They are burnt out, they are exhausted, and they fear for their lives. We are facing an election administration crisis, and we actually could solve this crisis by appropriating funding to our local election boards. So then they wouldn't need to seek other sources of funding. And we have the money to do so. We just passed $1 billion tax cut without a fiscal note. So the money is there. But instead of solving a crisis, we're making it worse. Restricting in-kind donations, creating barriers to funding, adding new cumbersome, illogical rules like requiring election workers to count ballot paper, knowing full well that in a county as large as Fulton or Cobb, that could amount to thousands and thousands of sheets of paper. So one has to wonder if this bill is deliberately designed to sabotage larger, more populous Democratic counties so that the state legislature will have an excuse to take over those counties too. Here's the thing, this bill not only impacts our local election system, it creates additional stressors on our court system by removing the requirement that ballots records must be retained and sealed. Now that ballots are unsealed, that means they're subject to open record requests to be handled by our court system. Any person from any part of our country who has no vested interest in Georgians can now come to our state, overwhelm our court system with endless open records requests without cause, and can use it to create chaos, to sow doubt, to delay the certification of elections by the state, and to perpetuate the big lie. So we are saying, come on, cyber ninjas, come to our state and look for those bamboo fibers. This is the other thing. This bill is intended to satisfy a base that cannot be satisfied. Now, the representative from House District 32 spoke about House Bill 886, which is Section 12 of this bill, the portion of the bill that deals with the custody, chain of custody for security paper ballot. During committee, we heard public testimony from Republican voters, and they came to our committee and they said, this bill doesn't do anything. It doesn't satisfy us. It doesn't restore our confidence in the election system. We want more. This is not what we want. That's what Republican voters said. And I sat back and I thought, wow, Republican voters are going to tank a Republican bill. These are the consequences of what happens when members of this body allowed and continue to allow lies and conspiracy theories to go unchecked. Because instead of being honest about the security of our election system, this lie festered, and now it is uncontrollable. I was a statewide poll monitor for the Democratic Party of Georgia for DeKalb County on January 5th. I was up before the first poll opened. I didn't get home until the polls closed. Throughout the day, I helped voters on both sides, Republican and Democratic voters. And I gotta tell y'all something. Republican voters are real angry. And they're not mad at Democrats. They're mad at y'all. I was at an early voting location that was not open on election day, which causes a lot of confusion. And dozens of voters showed up on both sides of the aisle. They didn't know where to go to vote. So I helped everybody as they pulled into the parking lot. Let me look up your voting precinct for you. This is where you go to cast your ballot. And during that time, a woman pulled into the parking lot in her van. And before she even got out, she started yelling. I couldn't hear what she was saying at first. And then, as she opened the door, she repeated, "They told me my vote didn't count. My vote didn't count. They said my vote didn't count. And I said, ma'am, where did you vote? And she said, I voted here at this early voting precinct. And I said, when did you vote? And she said, I voted last week. I said, who told you your vote didn't count? They told me my vote didn't count. And I said, well, let me show you. I'm going to log on to my voter page. Let me enter in your last name and your birthday, and let me show you how you can see that your vote counted. And I showed it to her. You voted at this polling precinct, you voted early, and you voted last week. And this is the information here, right here. And she thanked me, and she said, I'm just here to vote because my former president told me to come and vote. Y'all have done a disservice to your voters. And we've seen that. They didn't show up in 2021. Some of them showed up on January 6th at the nation's capital. And now a year later, they did show up in committee and said, this isn't enough. Because for them, anything short of overturning the results of the 2020 election is not going to be enough. And it's not going to end well. Because elected leaders, lawyers, alternative electors, and other people in positions of power allowed this big lie to fester. They betrayed their allegiance to our country and profited off this big lie instead of choosing to protect our democracy. And this is what's going to happen. Senate Bill 202 wasn't enough. House Bill 1464 is not going to be enough. We are going to continue to see this year after year after year. And for the record, liberals, we don't claim Mark Zuckerberg. Mr. Speaker, I yield the well.
Chair recognizes Representative Shannon for the balance of the minority report, about 9 minutes and 45 seconds.
Thank you, Mr. Speaker. I rise to speak in opposition to House Bill 1464. Several provisions in this bill really are written so loosely and the language is so poor that there's really not a way to comply with this bill. There's really not a way to know if you are complying with the bill. I want to first draw your attention to Section 12, line 745 through line 751, and I'll read the section. No ballots shall be handled without a poll official being present and without documentation on the chain of custody documentation forms of who is handling such ballots and when and why such ballots are being handled. After the activity requiring the handling of ballots is completed, such ballots shall be resealed in ballot boxes or other secure containers, which shall be recorded and witnessed on chain of custody documentation forms as specified by the Secretary of State and shall be signed by the persons having custody of such ballots. This section is something that I brought up in committee when we saw this provision in a separate bill that came through governmental affairs. The language is written so loosely, and it's requiring you to have a poll official present when ballots are being handled. What does the word handled mean? When you look up the word handled in the dictionary, it says to feel or manipulate with hands. Or a second definition is to manage a situation or a problem. So what are we talking about here? Are we saying that you've got to have a poll official available if you touch a ballot, if you move a ballot? I mean, literally, if you pick up a ballot that falls on the floor, do you have to call a poll official to supervise that? When we're talking about elections, it's really important that we have language that is concise because we know what happens when you have loose language in bills. What happens is prosecution is subjective. And that's when we start to see that when black and brown voters exercise their power and it's effective, we start to see more prosecutions. And so I brought this up in committee and I asked, and nobody could answer my question. I simply asked, if the majority of the really important activities are currently already supervised by an election official today, then what additional activities would you like to see supervised? And nobody could answer the question. This section, the way that it's written, to try to comply with this, it probably means that we probably better hold the primary election tomorrow if we want to have results by May 24th. because it's really going to slow down our system. And nothing is worse for the confidence in elections than taking forever to get results. The next section I want to draw your attention to is Section 18. And I know that my colleague spoke a little bit about what happens when you involve the GBI in elections, but I want to go into some more detail because this is very recent history that has not talked about enough that really should be talked about. Section 18 gives the GBI direct jurisdiction to investigate elections. That's not the way our law works today, but this bill will make it so the GBI can directly investigate. Much of the powers that this bill gives to the GBI, the state election board already has those powers. They already have the power to subpoena, and they already have the power to investigate. So then why involve the GBI? And you may say, and actually the bill sponsor brought this up and said, well, what's the problem with involving the GBI in elections? Well, it's very interesting because as Republican legislatures across the country work to ban the accurate teaching of history, it's time for a history lesson. There's a big reason why we should not be involving the GBI in our elections. This country, as well as this state, has had a history of using law enforcement to suppress, to basically do voter suppression. And this works by making folks scared to exercise their political power, and this has mostly been used on Black and brown communities. So I'm going to talk a little more about what happened with the Quitman 10, as people refer to it, but it really should be called the Quitman 12 because 2 people were additionally arrested after the initial 10. It's important to hear the details of this story to understand what really happened. When Black women flipped the majority white school board in the small town of Quitman, the state of Georgia arrested them and charged them with 120 separate felony counts of voter fraud. Let's talk about the Quitman 10, which was actually the Quitman 12, and how involving the GBI in Georgia's elections in 2010 destroyed the lives of many and had the effect of suppressing Black voter turnout, even though no one was ever convicted of any wrongdoing. Not enough people know this story, but it is relevant and recent history. This story is something that sounds like it's out of the 1960 voting rights, civil rights movement, but it's not. This is from 2010. When Nancy Dennard started working for Brooks County Schools in 2000, African Americans had no representatives in key county positions. And she felt that some school board members seemed more interested in preventing property tax increases than providing schools with sufficient resources. So she decided to run for a seat on the school board. After losing campaigns in 2004 and 2008, Ms. Dennard began to focus on absentee voters. The Republican-controlled state legislature, that's us, had made it easier to use absentee ballots in 2005, and Republicans were regularly relying on this voting tactic. In a special election in 2009, Ms. Dennard won. She then recruited 2 other Black women, middle school math teacher Diane Thomas and lifelong educator Linda Troutman, to run for school board in 2010. Most voters, Black and white, voted Democratic in Brooks County, so the July primary was the key race. Black turnout tripled from the previous 2 midterm elections, and both women prevailed, flipping the board from a majority white to a Black majority. 6 weeks later, state law enforcement officials under the authority of then Secretary of State Brian Kemp arrested Ms. Dennard at her home 4 days before Christmas. They took her away in handcuffs, placed her in a squad car, walked her into the police station. 11 of her political allies were also arrested, including Linda Troutman, Diane Thomas, and Thomas's sister, Lula Smart, who was an active campaign volunteer. The Quitman 12 were charged with 120 separate felonies. Mugshots of them in orange jumpsuits were plastered all across the newspaper front pages. The broadcast repeatedly on local TV and news, and also used on the Fox News station, talked about evidence of voter fraud. It is funny because history is repeating itself. Ms. Dennard told Yahoo News that she and her allies were arrested because they had upset the racial hierarchy. They thought they could make an example out of me that would kill the spirit of this movement, she said. I knew we had done nothing wrong. The arrest created an impression in the black community that vigorously exercising the right to vote would be punished. Sound familiar? Yahoo News interviewed 24 people involved in the case, including members of the Quitman 12, prosecutors, local officials, and state law enforcement officials, and reviewed more than 1,100 pages of documents obtained through open record laws from the Georgia Secretary of State and the GBI investigation. Some voters told investigators they received assistance in filling out their ballot, but most said they simply were given help to vote the way that they already wanted to vote. Prosecutors also charged the defendants with taking unlawful possession of ballots when they delivered sealed ballots to the post office for others, including family members, even though the law clearly states it is legal to deliver a ballot for a family member. District Attorney Joe Mulholland filed 120 counts in all, felony counts, which carried at least 20 years in prison for each of the Quitman 12 based on scant evidence. Their investigation revealed that the state, under Secretary of State Brian Kemp's direction, devoted extraordinary resources to investigating potential voter fraud in Quitman after local white officials and residents complained about the increase in black absentee voter participation. This is 2020 all over again. When the local district attorney asked the GBI to launch an investigation and promised to prosecute, so very heavy-handed here, the GBI agreed to work with the Secretary of State's voter fraud unit, even though the then director of the GBI, Victor Keenan, told Yahoo News, the Secretary of State's voter fraud unit has statutory authority to conduct those types of investigations. It's really extraordinary that the GBI would conduct voter fraud investigations. There has to be a clear-cut predicate for us to get involved because it's not our responsibility, nor do we have the jurisdictions to do those. Despite the lack of evidence, the state refused to dismiss the case. During the next 4 years, one of the defendants, Latasha Head, died. Lula Smart faced 25 counts and up to life in prison, and she fell into despair and even contemplated suicide. In the end, nobody was convicted of having committed any crimes, and this whole incident ended when Sam Olens issued an official opinion on June 15, 2016, advising what they did was not a violation. This is about one thing and one thing only, all of these bills. It's about overturning the 2020 election results.
Lady's time has expired.
Thank you, Mr. Speaker.
Previous question having been ordered, is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of House Bill 1464 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. What purpose does Representative Wilson rise? He waves. What purpose does Chairman LaHood rise?
Parliamentary inquiry.
State your inquiry.
Is it not true, Mr. Speaker, that we must protect Georgians' confidence that their votes matter and that fraud makes votes not matter? And is it further not true that to continue our tradition of defending the right to vote, we must do all we can, do whatever it takes to eliminate fraud? And is it further not true that a vote for this bill is a vote for election integrity?
I am sure the gentleman believes that to be true. What purpose does Representative McLeod rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I previously asked if there was a fiscal note and I was told no? The next question I would like to ask is, does it require a fiscal note?
I don't think that it would require one, and you've already appropriated funds for the GBI agents in the budget that we've already passed. What purpose does Chairman Knight rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that if we'd had this bill in effect, that the chain of custody issues that we experienced in Spalding County that are real could have been investigated and that we could have had real integrity in our elections?
If the gentleman so states.
Further, isn't it true, Mr. Speaker, that members of our citizens, our voters who did go on the my voter page, that they went and voted, that it was not registered on my voter page because the election supervisor and the staff failed to follow Georgia code and Georgia election procedures.
I'm sure the gentleman has investigated that and knows that to be true. What purpose does Representative Cannon rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I'm concerned that there might have been a member's button who was pressed before the vote came in order for another motion to possibly have been taken up?
I'm sorry, can you repeat that inquiry?
Is it not true that I am concerned that another member might have had their button pressed for a motion before the vote was called?
No, there was no button pressed before the vote was called. What purpose does Representative Hutchinson rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that it's not just one side of the aisle that is upset about voter integrity? Both sides are concerned about it, but only a certain subset are concerned enough to protest and make enough noise for us to have this many voter suppression bills.
Well, I'm sure the lady believes that to be true. All right, final one. What purpose does Representative Holly rise?
Parliamentary inquiry.
State your inquiry.
Sir, is it not true that while the hour is late and we've had such an extraordinary day in order to just finally take up this bill, at this point, we all are probably wondering, in the words of Rodney King, can't we all just get along?
That's not a bad sentiment. All right, have all members voted? Have all members voted? If so, the clerk will lock the machines on the passage of House Bill 1464. The ayes are 98. The nays are 73. This bill, having received the requisite constitutional majority, is therefore passed. What purpose does Chairman Werkheiser rise?
Make a motion
State your motion.
to immediately transmit the bill over to the Senate.
Gentlemen, I'm sure it won't come as a surprise to you to know that the Senate has been out for hours, so I'm not going to recognize you for that motion. What purpose does Representative Cannon rise?
To make a motion.
State your motion.
I'd like to move on reconsideration on this measure.
Lady has moved that the House reconsider or has served notice for reconsideration. The time to take that up would be now. All those in favor of the motion for reconsideration will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the lady's motion, the ayes are 70, the nays are 101. The lady's motion has failed, and reconsideration has been lost in this matter. Chair recognizes the Majority Leader of the House for a motion.
Thank you, Mr. Speaker. Mr. Speaker, I move that this House stand adjourned until 2 p.m. tomorrow, Wednesday, March the 16th, 2022.
We're back to bipartisan agreement, Mr. Leader. Love it. The Majority Leader has moved that this House be adjourned until 2 p.m. on Wednesday, March the 16th, March 16th, 2022. All those in favor of the motion will say aye. Haven't had that many ayes in years. All those opposed will say no. The ayes have it. This House will be adjourned until 2 p.m. Wednesday.